Hi, I'm Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer, and this video is prompted by a request from a designated broker who says that he is seeing the same problem over and over and over again. And honestly, I get this question so often that it's really important to reemphasize it. I'm pretty sure we've made a video on this topic before. Here's the problem. Buyer brokers attaching irrelevant document upon irrelevant document upon irrelevant document to buyer's offer. It may be the preliminary commitment for title. The entire preliminary commitment for title is attached to the buyer's offer. It may be the Form 17 is attached to the buyer's offer. It may be the Form 41D, the buyer broker's disclosure of the any relationship between broker and an inspector. It may be the law of agency pamphlet, or perhaps it's the lead-based paint pamphlet. We could go on and on with examples of documents that are not terms of agreement between the buyer and seller, yet buyer brokers attach those documents to buyer's offer. All of a sudden, buyer's offer is now 75 pages long, when in reality, it's long enough because when you have the purchase and sale agreement and a few addenda, it's probably in reality already 10 to 15 pages, pretty long document, but now it's a 75-page document because we've got a bunch of irrelevant stuff attached to buyer's offer. Let's start with a foundational understanding of what is a purchase and sale agreement. A purchase and sale agreement is a contract between who? Buyer and seller. Those are the only parties to the purchase and sale agreement. And what does the document between buyer and seller include? Terms of agreement between buyer and seller. So if we have a document that doesn't include terms of agreement between buyer and seller, then it does not belong in the purchase and sale agreement or in buyer's offer, which will become the purchase and sale agreement. So the law of real estate agency, for example, is that a term of agreement between buyer and seller? Of course not. It's a required disclosure or required notice that a real estate broker must deliver to a consumer. If you want to prove that you delivered it, which would be a very good practice, then have the consumer sign the front page of the law of agency pamphlet, deliver the pamphlet to them, keep that consumer signed one page in your firm's transaction folder. Same is true of the lead-based paint pamphlet. What about the Form 17? It's a really important document for the buyer to get and for the seller to get back from the buyer. But is it part of the purchase and sale agreement? Absolutely not. Does it set forth terms of agreement? No. It's a disclosure from the seller to the buyer. It does include the two parties, but it's not terms of agreement. It's a disclosure. It's not properly part of the purchase and sale agreement. So while it should be delivered back to seller with buyer's signature on one of the three signature lines, it's not part of the purchase and sale agreement. It should be delivered separately. Dear listing broker, attached, please find buyer's offer in one PDF, and in a separate PDF, here's a copy of the buyer signed seller's Form 17 disclosure statement. We could go on and on with the examples of documents that shouldn't be included, but let's focus right now instead on how this problem originates. Because I don't want to say brokers are, well, it's just a bad practice. That's how I'm going to describe it. And here's where the bad practice originates. Buyer broker assembles all of the documents that buyer broker wants buyer to sign, including the purchase and sale agreement and all the attached addenda. Great. And then the real estate, the law of agency, we want the buyer's signature on that first page, and the lead-based disclosure pamphlet, we want the buyer's signature on that first page, and the Form 17, and whatever else it is, the Form 41D, the inspector referral form. We want buyer to acknowledge receipt of all these things. And so buyer brokers compile all of that together in a single PDF and zip it over to the buyer to sign through an electronic signature process. Buyer compliantly does that and sends it back. Now here's where the problem exists. Buyer brokers, you've got to break apart that PDF. I don't care how you break apart that PDF. I'm not tech savvy, although I've been told that it's pretty simple to go into the electronic system and splice the document and take out the parts of the PDF that are not actually purchase and sale agreement terms. If you have to literally print it out and manually separate it, then do that. But buyer brokers, you are held to the standard of care of a lawyer when you prepare a purchase and sale agreement, including the offer for the buyer. It is not in keeping with the requirement, with the standard of care of a lawyer, to attach to the buyer's offer a bunch of documents that are not in fact offer terms. You run the risk of creating ambiguities, of creating a conflict of terms. It's just poor draftsmanship, and it will not pass muster in a courtroom under the test of reasonable skill and care compared to that of a lawyer. So buyer brokers, you've got to break apart the buyer electronic signed PDF so that when you deliver to the listing broker buyer's offer, it includes only buyer's offer terms. And if there are other documents that are important to deliver to seller, deliver them in a separate PDF. Dear listing broker, attached, please find buyer's offer. Attached, please find this other PDF with these other documents in it. We look forward to seller's acceptance so we can move forward towards closing. Okay, if you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.